In fact, Supreme Court goes on to say that auction to top bids may at times be against public good. एक बात हम स्पष्ट करना चाहते हैं कि हमारा ना कोई इरादा था और ना हमारे कोई ऐसी सोच थी कि हम इसके द्वारा जो सुप्रीम कोर्ट ने 2G जजमेंट पे 122 लाइसेंस को रद्द किया उस पे हम कोई टिप्पणी करें। अटॉर्नी जनरल ने सुप्रीम कोर्ट में स्टेटमेंट दी कि वो जहां तक 2G जजमेंट का सवाल है कि 122 लाइसेंसेस जो कैंसिल हुए वो हम जजमेंट को मानते हैं क्योंकि वो फाइनल ऑर्डर है और हम उसको लागू करने जा रहे हैं। और वो जो स्पेक्ट्रम रिलीज हुआ है जजमेंट के द्वारा उसको हम ऑक्शन करेंगे क्योंकि यही जजमेंट है सुप्रीम कोर्ट का। तो हमने पहले से ही कहा था कि उस जजमेंट पे हम कोई टिप्पणी नहीं करेंगे। In other words, we never intended at any stage, at the time of filing of the reference, nor can we do so in law, because through a reference, you cannot attack another judgment of the Supreme Court. So we made it quite clear that the judgment on cancellation of 122 licenses will be respected by the court and that auction will be conducted for the spectrum that has been available pursuant to the cancellation of the 122 licenses, and we are going ahead with that, and hopefully in terms of the schedule, why hopefully, we will make sure that in terms of the schedule, the auction will be conducted. सुप्रीम कोर्ट ने यह भी कहा है कि हर नेचुरल रिसोर्स को डिस्ट्रीब्यूट करने में अपना ऑब्जेक्टिव हो सकता है। मींस the distribution of each natural resource may have a different objective. And therefore, the government is entitled to take into account all those objectives and distribute that natural resource. And therefore, in each case, the court will look at this issue separately. And in case there is any wrongdoing in implementation, the court will certainly is free to interfere. But the court cannot lay down a method of allocation. कोर्ट ये नहीं कह सकती कि आपको इस प्राकृतिक संपदा को इस तरह से आपने उसका बंटवारा करना है, ये नहीं कह सकती कोर्ट। कोर्ट कॉन्स्टिट्यूशनल आधार पे किसी फैसले को रद्द कर सकती है, लेकिन ये कहना कि आपको इस तरह डिस्ट्रीब्यूट करना चाहिए था, ये कोर्ट नहीं कह सकती। तो मैं I really welcome the judgment of the Supreme Court, especially this last point that it is not for the court to lay down a method of allocation of natural resources. And what I'm really thankful about is that there is, this judgment has brought about enormous clarity, with which now the government can start taking decisions without fearing that there will be interference from other constitutional authorities. And therefore we welcome this judgment.
So there were certain questions that you were asked through the presidential reference. What will happen to advantage licenses, one-time fees?
You know very well the fifth question was, if the above questions are answered in the negative, then what will happen? But since they are answered in the positive, the other questions don't arise.
So the further decision will be taken on that
by the government. By the government.
And telecom companies will continue to get additional spectrum as they had asked the older licenses.
See, the auction conditions are now out in the open, and whatever the companies are entitled to, you will look at the auction conditions and bid for what you want.
The older licenses I'm talking about, which were given initial spectrum 4.4 megahertz, and the rest was.
We will take all those decisions. Whatever decisions are left to be taken, we shall take those decisions.
Sir, UPA government has a lot of legal luminaries like you. Then how come these kind of questions went to the Supreme Court? Has the government tried to outsource its governance to the Supreme Court?
I don't know what the purport of that question is. Because if there is a judgment of the Supreme Court that raises doubts, naturally we have to seek clarity. We can't go against the judgment of the Supreme Court, and therefore.
Reference also,